Welcome to Canada's most irreverent talk show. This is the Andrew Lawton Show, brought to you by True North.
Hello and welcome to you all, Canada's most irreverent talk show here, the Andrew Lawton Show on True North on this Tuesday, September 5th, just after 4 o'clock Eastern Time, where I am in Ontario, and also where Tamara Lich and Chris Barber, the organizers of the infamous Freedom Convoy, which arrived in Ottawa nearly 20 months ago, are standing trial. Now, this has been a long time coming in some ways, and I don't take any delight in the fact that Tamara and Chris are on trial, although I am going to put forward the belief that if they are going to be, swifter justice is better than nothing at all. And they've actually been denied the right to a speedy trial by virtue of how long this has taken, when, especially in Tamara's case, her life has been put on hold in very real ways by the conditions placed upon her by various judges. Now, these have eased somewhat in recent months. You may recall there was a time in which she was not able to speak at all, and since then she's been published a book, and she's sat down with me for an interview. Actually, she's been on my show once in response to the Public Order Emergency Commission report, and another when her book came out. We'll play a clip of that in just a little bit of time here. For Chris, he's been able to carry on with his life to some extent, but still both of them have had hanging over them for basically 19 months since the end of the convoy this possibility that they will be thrown in jail. They are facing a number of charges, the bulk of which pertain to so-called mischief. That's what they're doing. They're mischief makers. You know that little thing that you're accused of doing when you're a toddler by your parents, committing mischief? That is what these people are on trial for. Now, I'm not in Ottawa right now. I'm not in the courtroom, but I've been following along from some of the folks who are with what's happened there. And it sounds as though there hasn't yet been any criminality that's been advanced by the Crown, by witnesses for the prosecution. They even played a whole bunch of video clips from the convoy. One of them involved protesters shouting love over fear. Now, this was a prosecution piece of evidence. This was a piece of evidence that the Crown thought would really help establish the criminality of Tamara Lich and Chris Barber, which was a group of protesters in Ottawa with the Freedom Convoy shouting love over fear. Oh yes, that is as criminal as it gets in Justin Trudeau's Canada. This is going to be a long trial. It's scheduled for 16 days of sitting, but it's not actually 16 days straight because they're starting and stopping at a couple of points. So this is going to go into October unless they may have made a change of which I'm not aware, although the dates that I have are going to go into October, and at the end of which it may be a considerable time beyond that before we really fully understand the scope of what's happened here. But we can take a bigger picture look at what the last 20 months have shown us, which is that the Freedom Convoy won. The Freedom Convoy was preaching a message that was in fact a unifying one. And even if there were people in Ottawa that didn't want to hear what they had to say, and people that may have understandably not liked the sounds of honking horns, which were persistent for the first few days of the convoy anyway, it was a message that they were sharing that Canadians desperately needed to hear. It was a message that provincial premiers needed to hear, notably Doug Ford in Ontario, Jason Kenney in Alberta, Scott Moe in Saskatchewan, and a bunch of even non-conservative governments in BC. And perhaps you could also include in the mix there Quebec. I don't know if you call Quebec's government a conservative one, certainly not in form. But we also have to look at the implications of the convoy on Canadian politics. This was the movement that, well, there were other things going on, was really what led to the ouster of Aaron O'Toole, the ushering in of Pierre Poilievre, a guy who I know people can make any number of criticisms about how he and the Conservatives handled the COVID era. But Poilievre himself was, at least in those early days, a very clear supporter of the convoy's aims. Now, since then, he's equivocated a little bit on the specifics. Like, for example, when he told me in an interview that he thought it would have been better if they didn't bring trucks, to which I'd say, well, then you wouldn't have had a Freedom Convoy. But here we have the state trying to lay at Tamara Lich's and Chris Barber's feet the humiliation and shame that the state endured because of the Freedom Convoy, the humiliation and shame that Justin Trudeau endured because of the Freedom Convoy. These were the people that held a mirror up to the statists and authoritarians, the people who held the mirror up, to those who gave into fear and those who exacted control over every single person in this country, down to what you put on your face, to how you run your business, to if you can run your business, and yes, to what you put in your body. That was what the Freedom Convoy did. And what was interesting is that this protest, which began in a fight against mandates, a fight against vaccine mandates and vaccine passports, morphed into something far greater. As I remarked in a column at the end of the Freedom Convoy's time in Ottawa, and I have quoted myself, nothing more insufferable than someone who quotes themselves, but I get like one good line a year, so I like to milk it for a little bit. The quote that I am going to remind you of is when I said that the Freedom Convoy showed the lengths through which those who hate freedom will go to stop it. And the Freedom Convoy's great victory, I don't think, was it vanquishing COVID mandates, because let's be real, it didn't. Many of the COVID mandates, in fact, most of them in Canada, outlasted the Freedom Convoy. Now, whether the convoy set a precedent by which any other statist would be very careful and very cautious about putting these mandates forward in the future, I think is a completely fair discussion to have. But what the Freedom Convoy did is reveal in a very legitimate way. Well, illegitimate, but I mean legitimate in the sense of it was useful. It revealed in a very useful way exactly what people like Justin Trudeau and Chrystia Freeland will do when they feel their narrative is threatened. I'm talking, of course, about the Emergencies Act, which moved the discussion about the Freedom Convoy into entirely different territory. Remember, when the Emergencies Act came into play, even people who didn't like the protest started to say, okay, well, hang on, no, I didn't want to go that far with it. But right now, the government has claimed exoneration on the Emergencies Act because they were exonerated in some way by the commission, the Public Order Emergency Commission. Well, many of those who have been charged with COVID offenses have had their charges quietly dropped. The prosecution against Tamara and Chris has persisted and is continuing now, has just started this morning in Ottawa. And well, there are going to be a number of challenges still yet to come, and we'll talk about some of those this week. Challenges against the Emergencies Act that will go through various levels of court, continued appeals of other charges. Generally speaking, the courts have sided with the government on pretty much every substantive COVID challenge that's been put before them. Even when there has been a clear and undeniable breach of the Constitution, the measures that the governments have imposed have been saved by Section 1 of the Charter, which is to say the court has found that, yeah, you may have breached people's rights, but you were reasonable in doing so, to crudely paraphrase Section 1 of the Canadian Charter of Rights and Freedoms, a document which is tremendously powerful, but only when you have institutions that decide to be bound and governed by it. So I'm keeping an eye on what's happening in Ottawa right now as being one of the last real stands that the Freedom Convoy is able to make in court. Criminal law is a very, very high bar. There's a very high bar to be found guilty of having committed a crime. It's not just the balance of probabilities. There's no Section 1 that we can see invoked here. It is about, did these people do what the government said they did, and were those actions criminal? I want to welcome into the show here John Carpay, who is the president of the Justice Center for Constitutional Freedoms. Now, the JCCF is representing Chris Barber, one of the co-defendants, and I should also say, by way of disclosure, I sit on the board of the JCCF, although that has no bearing in this interview I'm doing today. John, it's good to talk to you. Thanks for coming on today.
Glad to be with you, Andrew.
So let's start off by talking about this in the broader context there. I tried to lay it out as best as I could. This is really the big criminal case that we will see coming out of the COVID era, and more specifically out of the convoy here. And when you look at the charges, it's really not clear to me as a non-lawyer, and perhaps it's clearer to you as a lawyer, what the criminality of this is.
Well, this is something that, we can get caught up in all the excitement and intrigue and what is the opening statement of the Crown prosecutor and the Crown's position. And of course, it's fascinating and thrilling and interesting, but we must not lose sight of the fact that this is outrageous that any criminal charges were brought in the first place. The federal government, Ontario government, the City of Ottawa, municipal government had ample law enforcement options, which they did not use. And these, we probably don't have time to get into all of them, but just a few examples: parking tickets, towing trucks that were illegally parked, issuing fines and tickets for municipal offenses, for having an assembly without a permit. There's all kinds of law enforcement, and the national emergency is supposed to exist under the legislation only if other law enforcement mechanisms are not able to deal with the situation. What we had a year and 7 months ago was a peaceful protest that was certainly causing inconvenience to people living in downtown Ottawa. But the regular law enforcement was not used, not applied. The local police, and you would know more about this, you wrote a book on it, Andrew, but the local police at a local level were in harmony with, dialogue, conversations, communications with the protesters. Police were telling them where to park their trucks. Anyway, the point is this: it's outrageous that criminal charges were brought against Canadians for doing nothing other than peacefully exercising their charter freedoms of expression, association, and peaceful assembly.
One thing that I find interesting on that note is that Tamara and Chris, whatever people think of the charges that they had laid against them, they were not even charged under the Emergencies Act. They weren't even charged under that authority. They were charged under the Criminal Code of Canada, which I think supports your point that there was an existing authority available to law enforcement when these charges were applied.
Yeah, it's and then when you look at the heart of it, well, you look at the mischief charges, mischief in the Criminal Code, Section 430. There's 4 different heads of it. One of them is to vandalize or damage property. That's one form of mischief. Another one is to interfere with the lawful use and enjoyment of property. And, on that note, I suppose that if you park your vehicle illegally, it's still quite a stretch to say that you're lawfully interfering with the use and enjoyment of property. So to have moved that on to a level of a criminal accusation is just reprehensible. It's also reprehensible that Tamara Lich spent a total of 49 days in jail in respect of a criminal charge that, if she is convicted, which she should not be, she's entirely innocent, but if she is convicted, she's not going to be spending any time in jail after conviction, yet she spent 49 days in jail.
Yeah, and I look at that and I see just the weirdest thing about that is that Tamara Lich, of the two, and I'm not saying that what she went through, Chris should have gone through, but of the two, she didn't even have a truck. So, her right to protest is as defensible as it gets, because all of the disruptions that the critics of the convoy brought up had to do with vehicles, whereas she rode shotgun with Chris Barber on the way there. Now, again, I'm not saying that the charges against Chris are any more reasonable, but it's strange that she has become the focal point of the state's ire. And I think, ultimately, if I'm to try to understand why that is, it was because she was the focal point as being the inspirational force of the convoy. So she is the head of the snake to the government, if you will, and they think that they can make an example of her, it seems. But that may be fine if you're trying to craft a plot or a narrative, but that's not the way the law works.
Well, what's also disconcerting is the blatant double standard. When we had Aboriginal protesters, I don't know if they were Aboriginals or environmentalists or both, but this was in March of 2020, and they were blockading railway lines. It was costing millions of dollars in damage. And the Prime Minister's public statement was that he would like to sit down and meet with them. And there were no criminal charges. And there could have been, based on the fact that there was definitely interference in the lawful use, lawful enjoyment of property. When you get into a physical blockade and you stop trains from moving goods, and you have perishable goods that are rotting, you're causing millions of dollars of damage. Arguably, that could have been a time for criminal charges. And yet the Prime Minister says, he wants to sit down and meet with these people. It's the same double standard we saw with COVID. If you were, you might remember Queen's Park, Doug Ford denounced anti-lockdown protesters as a bunch of reckless idiots who were endangering everybody's lives.
No, you got to quote him directly, John. A bunch of yahoos. That was the line. Yahoos. A bunch of yahoos.
And then not long thereafter, when people are marching in the streets against racism, all of a sudden Trudeau and Ford and the chief medical officers, nobody will denounce a protest against racism, which almost makes you think, is COVID a political virus that knows that if it's a good cause, it's not going to spread amongst people, but if it's a really bad cause like protesting against lockdowns, it's going to spread. So this is really disconcerting that you have Chris Barber, Tamara Lich, and many other Canadians as well. These happen to be the most famous, who are criminally charged. When you have another example, the Crown prosecutors in Manitoba ignored the destruction of a statue of Queen Victoria, which was torn down July 2021. It's a good thing nobody got hurt. The thing weighs a ton or more. And they topple this statue, destroy a statue in full public view with police watching. That is criminal activity. No charges laid.
We've seen in the last few months in particular, I mean, long after COVID and the convoy, we've seen a huge number of stories across the country of, in many cases, violent offenders that have been released on bail, are rearrested, or released again. We've seen a lot more of a discussion in the political context about this. I know Conservative leader Pierre Poilievre has been talking about it. I know a lot of provincial governments have. And it really brings around the point. I mean, you mentioned how long Tamara spent behind bars. Chris was a little bit more fortunate with his bail conditions. But even so, there have been violent offenders that have had an easier time staying out of jail than Tamara Lich has.
Which makes us a banana republic with polar bears. You know, we used to look down our noses at countries where if you criticize the president or the prime minister, the next day you would suddenly find yourself charged with fraud or rape or murder or embezzlement or theft, and you'd be in prison. And of course, everybody knows, well, it's because you criticize the prime minister that you're now suddenly facing these trumped up criminal charges. And this is what we've descended to in Canada, where the blatant, willful criminal activity of destroying a statue of Queen Victoria in Winnipeg in July of 2021, condoned by the police, condoned by the Crown. You've got criminal conduct by people protesting for the environment and or Aboriginal rights. And there's just that double standard. But if you speak out against the prime minister and the lockdown measures, you can expect to be criminally charged. It is so nakedly political, and it's very sad that our country has descended to this point.
I know you're not litigating in this particular case, but are you able to offer any bit of a roadmap for the audience, John, as to the process here? It's a 16-day trial. I've been following bits and pieces on Twitter today, and I see they're talking about evidence, and both sides are entering a bit. But what's the roadmap this is going to follow here?
So after the trial is over, in about 99.9% of cases, the judge will reserve judgment. So the judgment will be forthcoming in what I would predict would be months, not weeks. If it's a short, simple trial, you know, somebody's accused of shoplifting and whatever, right? You might get a judgment in a few days or a week or two. I would not be surprised if it took 3, 4, 5, 6 months for the judge to sift through all the evidence and write a judgment. So we're going to get a conviction or an acquittal in several months' time. And the Justice Centre's involvement is that we are providing for the criminal defense for Chris Barber, and we're also defending Tamara Lich in a civil action that has been launched by Ottawa resident Zexi Lee, who is suing for $300 million over losing some sleep due to horn honking at night.
Well described, sir. Let me, I mean, you mentioned the shoplifting case, and let me bring the shoplifting example, because this is a very simple crime that people can understand, which is, a guy is charged for going into a store, putting a chocolate bar in his pocket and walking out. And when you are charged with that, you basically have, as I understand it, 3 real defenses. You can say, well, actually, no, that wasn't me. That was someone else entirely that did that. You can say that was me, but I never actually put the chocolate bar in my pocket. I walked in with a chocolate bar, I looked at it, and I put it back in and left. And then you get into, I was not particularly mentally sound at the time, and I'm not criminally responsible. But, the pretty clear, easily understood defenses there. Either someone else did it, or no, that was me, but I didn't really do it. In this case, it's something far more complex. There is no, surveillance footage of the chocolate bar going into a pocket that we can really hinge on here. So what is the defense? Is the defense that, yes, I did all the things you're saying I did, but they aren't criminal?
Well, to answer it in a roundabout way, what the Crown needs to prove is the mens rea, which is the guilty mind, and the actus reus. So they have to establish, let's pick Chris Barber as one of the two examples. They have to establish that Chris Barber interfered with the lawful use and enjoyment of property as set out in Section 430. If it's an obstruction charge, that he actually interfered with the police carrying on their duties. So they have to prove beyond a reasonable doubt that Chris Barber did the criminal act. And that depends on how does the wording of the criminal code match up with the reality? Did he actually do that? Did he, if he parked his truck illegally, I don't know if he did or not. And in my view, if he did, he should have just gotten a parking ticket. But was the illegal parking of the truck, if it was illegally parked, does that constitute criminal conduct? And then the second, the mens rea, the mental component to be found guilty is that you intended to lawfully to interfere with the lawful use and enjoyment of property. There has to be an intention there in your mind to commit the crime. Both of those have to be proved beyond a reasonable doubt. And so to me, it seems the Crown has an uphill fight. If the judge is unbiased and fair-minded and does not want to engage in virtue signaling towards the political establishment, I have every reason to assume that this judge is fair-minded and independent. I think the Crown has an uphill fight.
Is there a constitutional protection for, I guess, what people on the left often call civil disobedience? Where is there a constitutional protection for, yes, maybe this wasn't exactly following the letter of the law, but I was doing it because it was a form of political expression, which is protected under the Constitution, at least in theory?
Short answer is no. The way that civil disobedience is supposed to function in theory is that people are willing to break a law which they sincerely believe to be unjust, and thereafter they're willing to accept the consequences. I'll give you sort of an easy example that a lot of people could relate to. You've got bubble zone legislation around abortion clinics that in most provinces, to my knowledge, it's illegal as a provincial offense, not criminal, but it's illegal to protest within whatever 10 feet or 100 feet of an abortion clinic, even if the protest is entirely peaceful. And so it's illegal. Now, civil disobedience would mean that somebody says, I know that I'm committing an offense against a provincial law. I'm going to do it anyway. I'm going to get arrested. I'm going to be found guilty, and I'm going to suffer the consequences of a fine or jail time as a part of a deliberate effort to expose how unjust this law is. So that's civil disobedience in a nutshell. It's deliberate disobedience with a willingness to accept the consequences for the purpose of exposing the unjust law, but it is not a loophole in the criminal process. So the criminal process is still the same. Did you do it? Did you intend to do it? And why you did it, if it was because of sincere, deeply held, profound convictions, that's neither here nor there.
But again, I'm curious, and I'm glad you answered that question. I also want to distinguish that from what we're talking about here, because in this case, we do have a real disagreement between the Crown and the defense as whether a law was even broken.
Well, speaking of civil disobedience, another example of disobedience would be for truckers to illegally park their trucks with the knowledge that they're going to get ticket after ticket after ticket. Because if you don't move it after an hour or two, I think the municipal authorities are entitled to come back and give you another ticket again, right? They're not limited to one a day. And so the civil disobedience that I think that the truckers were willing to engage in.
Just if I could jump in on there too. And I would say beyond that to tow it. But the reason the cities didn't tow the trucks was because of their own bureaucratic incompetence, because they couldn't find tow truck drivers willing to do it. So that's, again, they had that tool available to them.
The other component, at least for some of the trucks, is that the police told the truckers where to park their trucks.
Yeah.
And so some trucks were illegally parked, but it was with the knowledge and consent of the police, which then throws into question completely how illegal was it when you've got police giving you a green light on it.
Yeah, very, very well said. I mean, obviously, we're going to follow this along here. I saw one report from within the courtroom today that Tamara has been restricted from being unaccompanied in downtown Ottawa. She had to get judicial
dangerous
permission.
Woman that she is.
Yeah, she had to get judicial permission to go and get, I said a sandwich on Twitter. I don't know if she got a sandwich or a bowl of soup or a wrap or a pina colada. I don't know what it was, but she had to get judicial permission to go and get lunch in downtown Ottawa without her lawyer. Now, I don't know if any of this is standard practice in criminal proceedings. I mean, the big challenge that I see here is that it's very difficult, and I'm not making a swipe at the judge herself. I don't know the judge, and I have no reason to suspect she's biased. But this is really at stake in the Freedom Convoy cases are these dueling narratives of the downtown Ottawa resident experience versus everyone else in the country's experience. I'd say, and it's very difficult to separate a judge who lives in Ottawa from an Ottawa resident. And this was a challenge in one of Tamara's bail hearings, where you had a judge who, as she was throwing Tamara in the slammer, referred to our city.
This is what makes the job of a judge very difficult and very demanding, because a judge is expected to rise above it. You take, for example, let's say that somebody in Saskatchewan is accused of murder and is going to be tried in Saskatchewan. Even if the judge doesn't live in the same city where the alleged crime took place, there's going to be media coverage. And so judges are expected, as a job requirement, to separate themselves as much as possible, to disregard the media coverage, and to look only at the facts that are placed before the court. Now, I think in a murder trial, that might be a little bit easier, because you can just disregard the media coverage. The judge can disregard. In
general,
the media
disregarding
coverage.
Media coverage is advisable on many things.
It's advisable. In Ottawa, it could be, for this particular trial, it could be more difficult if the judge was personally inconvenienced because she couldn't make it to a medical appointment on a given day, because there were a lot of trucks parked illegally in downtown Ottawa. If that was the case, again, entirely hypothetical, she would have to detach from that and just kind of say, okay, well, I'm going to put that on the back burner that I was late for an appointment because of the truckers, and just focus exclusively on the evidence that is presented before her in the courtroom. It's a very difficult job, and I wish her well as she evaluates the evidence.
All right. Well, we will definitely keep an eye on this. John Carpay, president of the Justice Center for Constitutional Freedoms. Always a pleasure, John. Thanks for coming on.
Thank you, Andrew. Have a great rest of the day.
All right. Thank you. And again, I'm not holding back from people the details of the case right now. There hasn't actually been too much in the way of detail, but we are going to follow this along. And I'll point out, there was one tweet I saw earlier. I want to bring this up again if I can find it. This was a tweet from Robert Krajcik, who is with Rebel News, and he's there in Ottawa. And we even have the tweet. Okay, great. I just flagged it for my own reference, but good on you, Sean. Tamara Lich's defense attorneys both object to the Crown's derisive description of the Freedom Convoy as an occupation of downtown Ottawa. And Lawrence Greenspan, who is the criminal defense lawyer working with Tamara Lich, he actually just spoke with reporters outside the courthouse a little while ago. I saw a clip of that on Twitter, which that one I didn't tell Sean about. So if he doesn't have the clip, that one's not on him. That's on me. But he was asked, and he said, look, we've got, Russia occupying Ukraine right now. Let's not, diminish the word occupation to this protest in Ottawa. But I wanted to bring this up because it shows how language matters. Because if you had a judge that were to say just nonchalantly, oh, yes, the occupation in Ottawa, well, that's going to impart a little bit of bias there. So the Crown is trying to use that word. Defense is saying, no, you're not going to get away with using that word. Now, in the end, both sides are going to describe this protest the way they want to. What I can say is that I would be very, very, very nervous if I were Tamara Lich's attorney or Chris Barber's attorney, attorney, which would be really bad for them because I'm not an attorney. But if I were to be the attorney for either of them, I would not want a jury trial on this, just given the pool from which, I mean, it would be like 9 civil servants or something like that. But in any case, not 9, no, 12. Why am I shrinking the size of a jury? It'll be 10 civil servants and 2 non-civil servants or something. I had to get to 12. I was thinking of the Supreme Court, so my numbers were all wrong there. Actually, it's 6 for civil, if I'm not mistaken, but 12 for criminal. So Sean's saying 12 angry men. That's the way he remembers. Yeah, but if you got 12 angry men on the jury, it's probably good for the crown. We are going to talk about this more tomorrow with Eva Chipiak, another lawyer. We also have on Friday a full-length interview with Tom Marazzo, a repeat guest on this show, and also a gentleman who is writing or has written a book, which is coming out tomorrow about the convoy. But before we wrap things up today, it is back to school time. I do not have children, and it's been a great many years since I have gone back to school, but all of my friends with kids have been sharing their photographs of their kids going to grade 1 and 2 and 9 and 14 in one person's case, but that was a special case. But we also have a little bit of an odd dilemma in that we can talk about all the weird things that happen in schools. But for the most part, I think kids, when they go into school, probably have a pretty narrow set of interests. They're thinking, okay, I don't want to be back in school. I'd rather be away for the summer again. Okay, I'll get to see my friends. And, maybe there's a teacher I like or a particular class I like. I don't buy into Global News's version of things, though. Global ran this story that purportedly says, Canadian students are kicking off the new school year with climate change and AI top of mind. Climate change and AI top of mind. Now, I found this to be odd. Now, it's not a global article. It's a Canadian Press article. So I'll share my scorn for CP. But I was thinking of this, and then I was reading the article, and I was expecting, okay, maybe they found 3 or 4 woke students that are saying, wow, I really hope I learn more about climate change. So do we have the text of the article, Sean? We do. See, Sean, you're getting your bonus today. The article actually says nothing to support what the article is about. It says many students are likely feeling a mixture of nerves and excitement as they begin another school year. And then there's a paragraph that says, with disruptive pandemic measures seemingly behind them, parents and educators say a new crop of issues may affect classroom learning this year, including AI technology, affordability, and climate change. Then there's a paragraph about wildfires. Then there's a paragraph about BC saying no schools were damaged by wildfires, but students will still be affected. And then there are a few more paragraphs about nothing to do with anything. So nowhere in this story do they quote a parent, a teacher, a student, a study, an expert, or anything that suggests there is at all any support for the fact that students are somehow paranoid or nervous or top of mind for them is climate change or AI. So it's a great example of the media just literally manufacturing a story that has no bearing in reality. But that is not all. Global News has been going for the big award this week. I don't know what the award is. We'll have to come up with an award. Maybe we'll bring back Fake News Friday or something. But there was another one here that was talking about New Brunswick parents worrying of bullying at school because of changes to the gender identity policy. Now, this is the New Brunswick policy that basically says if you are under 16 and you want to change your gender at school, a parent needs to consent to it. This is a very popular policy. Parents around the country agree with it. It really is quite modest. It doesn't out trans students to their parents at all. It just says they need to provide parental consent. And if they're not comfortable talking to their parents, the school will let someone help them out with that. But you read the article and it is 2 parents that are in it. And they don't even quote the parents, by the way. Sean and Amanda Rouse, parents of a transgender teen in, I'm going to try to say it. If you're in New Brunswick, please let me know how wrong I've gotten it. Quispamsis, Kipemzi. I don't actually have any idea. So we'll say Q New Brunswick. Now I'm actually going to look this up later. Can't you just do dildo Newfoundland? I can say that. But Amanda Rouse says her 14-year-old has been called slurs and told to kill herself. She says the bullying is a heavy burden for her child and expects it to continue as schools reopen from summer break. I think that it is horrible that the Rouse's child has been subjected to bullying. I think bullying is terrible. I think it is hurtful, whether it is because someone is trans or gay or of a particular race, or in my case, fat. That is completely wrong and can be very harmful to children. But I would be remiss to not point out that has nothing to do with the policy in New Brunswick at all, because as the mother acknowledges, this bullying predated the change in the New Brunswick gender policy for schools. It predated it because this has been a persistent problem. So the fact that this policy, which doesn't even affect the child referenced in this story, because there is parental consent, means that it is just fear-mongering and using children going through whatever they're going through as political pawns. And the media bought it up. And what do you know? Not Global News, Canadian press again, after all. So CP is serving them up. Canadian press is eating them off the platter. And we're all supposed to go along with it, that this is just the shabby journalism that we are having foisted upon us. So that does it for us for today. We'll be back tomorrow with more of the Andrew Lawton Show here on True North. Thank you, God bless, and good day to you all.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.